Hey everybody, Mauricio here, McElroy.com legal advisor, and today I wanted to talk to you guys about the 7 tips that I give my real estate investors prior to executing a purchase and sale agreement. Tip number 1 is pay a little bit more attention to the LOI, the letter of intent. Now, as you all know, the LOI is similar to an MOU, a memorandum of understanding. It's not really a legal agreement, but it's kind of like the meeting of the minds. It's the two parties getting on the same page. And so make sure that you're putting into the LOI all of the major terms that you plan to put on the contract. A lot of time people leave things out from the LOI and try and negotiate that at the contract level, but by then it's a little bit harder because if you don't put it in the LOI, the seller's going to be more apt to push back on something if it wasn't in the LOI. Tip number 2, get extensions. You'll be amazed how many times I see real estate investors get into a contract and not have at least one extension in case they can't close on the property. This is particularly important if you're raising capital because there's a whole bunch of things that can happen between the time you execute the contract and the time you can fund. Maybe you're short on the raise, maybe something came up. You want to have as many extensions as you can possibly negotiate. I would recommend at least 2, but you'll be surprised to see how many people don't put extensions whatsoever. Now, you may have to pay for the extensions, you may have to go hard, but you want to give yourself that out so that if for whatever reason you can't close on the closing date, you've got that extra 30 days or even ideally 60 days. Tip number 3 is once you have an executed LOI, get into contract as fast as possible. You will be surprised how many times sellers tend to shop around their LOIs. So just because you have an LOI signed doesn't guarantee that you're actually going to end up with the property. So the longer you wait between the time you get the LOI and you execute on the contract, the more likely it is that that seller may have a change of mind, somebody may come up with a better offer. There's still a chance that that person may cancel that LOI somehow and end up selling the property to somebody else. Tip number 4, use a real estate attorney. This is particularly true if you're raising capital. It always blows my mind that people end up raising $1 million or $2 million from investors and don't spend the time or the money because the risk-reward ratio doesn't make sense. Think about it. Your reward is that you're saving $10,000, $12,000, $8,000 on real estate fees, which by the way are paid from the project, but your risk is that something gets missed. Some easement that was in the report doesn't get picked up, or there's some environmental issue, or there's something happens in the contract that prohibits you from doing whatever it is that you wanted to do, and you end up hurting your investors, and even worse, you may potentially be liable to those investors. So you're raising $1 million or $1.5 million or $2 million. That's your risk. You could lose that $2 million if your investors end up suing you for some reason, and your reward is simply $10,000, $12,000. So the risk-reward ratio of not having a real estate attorney really doesn't make sense. Tip number 5, make sure the contract is assignable. Many times you enter into the contract in your personal name or in the name of your LLC, which is fine, but you want to make sure you have language in there that allows you to assign the contract to another LLC so that you can close in the name of that LLC. That's particularly important if you're, again, raising capital, because when you have investors, you're going to end up closing in a different LLC. So make sure that language is in your contract. Now, it doesn't have to be a blanket language where you can transfer it to anyone. You can limit it where you can transfer it to an LLC that you control, but you want to make sure that language is in there so that you're not forced to close in your personal name or in the name of an LLC that you ultimately didn't want to have. Tip number 6, make sure that the seller is actually the one that owns the property. You'll be surprised to learn that many times the property might be owned in an LLC or in a trust, and yet the contract is signed by an individual or some other entity. So you want to make sure that you're entering into the legal contract with the party that actually owns the property. And finally, tip number 7, which is probably one of my favorites, is try and set your due diligence date not from the calendar, but actually an event. So instead of starting due diligence on a particular day, make it contingent on receiving, for example, all of your due diligence documents first, prior to that due diligence period starting. That'll typically buy you a couple of extra days or sometimes a couple of extra weeks because the seller usually drags their feet in getting you whatever due diligence documents you need. Now, it's really, really important here to make sure that you clearly define when that date happens, when that event is triggered and all of those documents are in. We want to make sure we're very, very specific. So again, it's super important to be working with a really good real estate attorney so that language can be in there. But if you can pull that off and not have your due diligence start until all those documents are in, that's going to buy you a couple extra days, and I've even seen a couple of extra weeks. So hopefully those tips were useful for you, and if you've got any questions, as always, feel free to leave them in the comments.